Good evening and welcome to 13 Reports. Legal malpractice, a subject that has not come up often in the past and seems to be coming up more and more these days. I think I'm going to start off with you, Mr. Doug Peters. You have been up in Detroit representing clients who have been suing attorneys for some time now. Why is it that all of a sudden we're hearing about legal malpractice? We've heard about medical malpractice for years. What has happened?
I think there are a number of reasons, Mike. I think that there have been legal malpractice suits for several hundred years. I think that a number of suits either don't reach the suit stage or they are settled historically behind closed doors. Increasingly, though, there is the effect of the consumer movement. And as consumers assert their rights against Ford Motor Company for exploding Pintos, against doctors for medical malpractice, they now look to attorneys who make mistakes or negligent errors in the handling of their cases for money damages, to recover money that they would have otherwise had not the attorney made the mistake.
But wasn't it a problem for many years that in a close legal community where the attorneys are good friends with one another, and there weren't that many of them, that it was a pretty difficult thing to do to say, well, you know, John, I'm going to sue you because a client came in and said you missed the statute on something. And all of a sudden now that doesn't seem to make any difference.
No, it still is a problem. Actually, in small communities, even in big cities, a number of lawyers will not accept legal malpractice cases. They feel uncomfortable about some lawyers who represent clients in legal malpractice actions. But I think there has been a change for the better, and that change is that there's an increasing awareness of lawyer responsibility, and lawyers are increasingly aware that when they make mistakes, it's the bar's obligation and lawyers' obligations to make sure that those clients don't suffer because of those negligent errors.
Mr. Bob Rowley, President-elect of the local Bar Association, some of this headache will be yours next year. What does the bar feel about this problem? Because it'll affect your insurance rates, and it also is a problem within the bar itself. What do you think about that?
Well, I really view malpractice insurance as almost a necessity as much as I do casualty and automobile insurance today. And my feeling is that with the advent of consumerism, with the increased number of lawyers, we have about 35,000 lawyers a year coming into the legal profession. That and lack of supervision when they first commence practicing is a problem. The Bar Association does have a responsibility, of course, to all new lawyers, and when misconduct or when malpractice becomes misconduct, then it becomes a matter for the Bar Association to look into through its grievance procedures.
Now that's an interesting point, because many people assume that if an attorney is sued in malpractice, that also has an impact among the members of the bar in that he'll be disbarred. But that's not necessarily true. They're two different things.
That's true. And I said malpractice when it becomes misconduct. Many times malpractice is the result of negligence, which is not an intentional act. And not all grievance procedures necessarily are intentional. Sometimes they can be mistakes also. For example, you might have a good lawyer, a very good trial lawyer, who might have a bad habit of losing his temper in court and behave very poorly in front of the judge or to the other party. And that is probably a case for grievance as well as a case for malpractice, Doug, I would assume.
If the client is injured by the attorney who loses his or her demeanor and causes the jury to think, well, this person doesn't have a real good case or else that lawyer wouldn't be yelling and screaming. If you could ever prove that, that would probably be grounds for a malpractice case. Those are not the types of cases that we frequently see, however. Litigation errors as a basis for legal malpractice are very difficult to establish unless the litigation error is missing a filing deadline or breaching some other fairly clear-cut rule or procedural responsibility. The problem with litigation errors as a basis for legal malpractice is that the process of determining guilt or innocence in a criminal situation or liability or non-liability in a civil situation is the subjective nature. To find out how the jury would have voted if the attorney had not lost his or her cool, let's say, it's very difficult to establish.
But in every case, somebody's going to lose, somebody's going to win. Now, the losing party may be a little upset, especially if they thought or had been not necessarily promised, but the attorney had intimated, but boy, we've got a great case here. There's no problem. I can see us winning the $5,000 to $10,000 that you want. And then the jury comes in and, sorry folks, it went the other way. Now, is that where the legal malpractice suit comes in, because that person is upset? Is that the problem?
Go ahead.
I don't think so. I think that attorneys such as myself or any potential plaintiff's attorney has a responsibility to screen any case. Just because a client wants to sue somebody doesn't mean that a suit should be filed. Whether it's an auto case, a medical malpractice case, or a legal malpractice case, the attorney approached by a client should investigate to see whether or not there is a basis for filing a lawsuit. Unhappy clients, unfortunately, do not create a cause of action in legal malpractice. There must be a deviation from the standard of care, and there must be an injury that is caused by that attorney's deviation from the standard of care.
Well, all right, the medical community talks about standard of care all the time. I sense a problem in the legal community in that what is the standard? I don't think that people have talked about it, other than missing statutes and missing simple things. How do you know when an attorney did the right thing, if he took the right tact in the case? Does the bar ever try and sit down with attorneys and talk about that?
Well, no. We do have a lawyers' advisory and ethics committee, in which lawyers have the right to submit questions to our committee as to what they should do in ethical cases, and some of them are very hard questions. For example, I was talking to Doug before the program here about, suppose that you're representing a client in a personal injury suit, and the statute is about to run, and you can't locate him. What is the lawyer supposed to do? And of course, a lot of that is predicated on what's gone on before, and there really isn't any very simple answer to it after the fact. Most of it is something that is before the fact that the lawyer should be aware of, and there are means by which we can educate the lawyers. We do have a continuing legal education program in the Bar Association on different subjects, and the idea is to help the lawyer to become a better lawyer after he's out of law school, and to be faced with the more practical problems of trying a lawsuit and the various aspects. So we do, as the Bar Association, try to educate them, try to keep them educated, try to keep them current with all of the new laws and the many things and ways that we can help them in the practice.
It seems almost impossible, looking at the great weight of all of the decisions that come out, all of the various facets of the law, to try and keep up with all of that. Is the bar starting to recognize specialties? Doctors have been talking about specialties forever. I mean, and it seems like there's over-specialization, but what happens when a person is into patents or copyrights, and someone who's just out of law school, a friend comes in and says, will you take this case? And he says, well, gee, I don't know much, but I'll try it if you want to trust me. And of course, he doesn't know that much. Is there a standard of care for every element of the law?
Well, that's a good question, because that's a question that hasn't been really resolved in the state of Ohio. And with the advent of lawyer advertising, this has brought on a whole new ballgame about many things. And if it's not handled properly, this is going to be a floodgate for a lot of malpractice suits, as far as I'm concerned. Because if a lawyer advertises he is a specialist in a certain field, if he's a trial specialist, he better be a trial specialist if he's advertised that way.
Does that mean he has to be Superman and not make any mistakes?
He hadn't better make any mistakes, because he's leaving himself open to some claims for malpractice in my estimation. And so far, the state of Ohio has not yet come up with any plan of specialization. There are several ideas about what to do about it, whether you can be